Hello and welcome to the next episode of Fresh Starts Talks. Today I'm joined by Suzanne Kingston, who is a consultant at Mills and Reeves, as well as Carrie Olsen in Jersey. She's widely known as an expert in family work, particularly around complex financial issues, and is actually referred to often as the Queen of Arbitration, and accredited with spearheading family law arbitration, not only in England and Wales, but across the world. And also won the Lifetime Achievement Award in the Magic Circle Awards in November 2020. So thank you, Susan, for joining us. It's really great for you to have given up your time, particularly as the conversation we're going to have today is about arbitration, and who better than the Queen of Arbitration to have that conversation with. So thank you. Firstly, just for those people who don't know, what exactly is arbitration?
Well, first of all, thanks very much for inviting me. Really good to be here. Arbitration is like a private court. So it's a bit like the NHS versus the private health sector. So it's adjudication outside of the court process with a trained arbitrator, and generally with lawyers involved, but sometimes without. So you can effectively get out of the court system and have an arbitration outside the court system, but it's very similar to being in court, apart from the fact that when you're in arbitration, there's a lot of, the parties play a very pivotal role, and they probably are more interventionist and take more part if they want to than you would in a court. Okay.
So arbitration is available to anyone, providing they want to kind of have that arbitration session and pay obviously the fees that are associated with that. But anyone can do it, or?
Yes, anyone can do it. As I say, typically lawyers represent people in arbitration, but you can have arbitration with just the parties, the husband and the wife, or the couple, the mother and father, in relation to either their finances or the children, or both. And so there are some things which can't be dealt with in arbitration, some complex areas which can't be dealt with in arbitration, but practically everything else that a court could do could be dealt with in arbitration.
Okay, and an arbitrator, is it a judge who would be the arbitrator, or is it another type of legal professional?
It's a trained arbitrator, and the people who are trained, who've had to go through some rather rigorous training that I conduct with an exam as well, are either retired judges, barristers, or solicitors. And so there's quite a wide pool for you to choose your arbitrator from. There's probably about 330 arbitrators now in England and Wales. And so you can go on the website, you can see who specialises in children cases, who specialises in financial cases. And probably with your solicitor, but as I say, you can be a litigant in person as well, you can choose your arbitrator.
And I guess, what are the benefits of having a solicitor versus not having a solicitor and representing yourself? Kind of what scenarios would work with each?
Yeah, I mean, I think if you can afford to have a lawyer, it's good to have a lawyer representing you, because obviously they've been through these sorts of processes many times before. They know the law, they know how best to present a case, how best to represent you. But it is also possible to do an arbitration just with the arbitrator as a couple, and the arbitrator will be very conscious that you don't have lawyers if you don't, and they'll try and help the two of you. But obviously the key point for the arbitrator is that they must remain impartial and independent, so they're not able to give either side any legal advice, which is quite tricky. If they can see something going wrong, they may say to a couple, actually it'd be better if you had lawyers with you. Although you're paying for the arbitrator, actually one of the benefits that we've seen of arbitration is that it can be very good value, because essentially you're dealing with your case probably much more quickly than if it was going through the court process. So rather than having lots of satellite litigation, which is what happens when you're dealing with a case for a long time, the average court case probably takes 12 months, 18 months, up to 2 years. If you're doing that, then there can be a lot of spats in between, whereas if you're in arbitration, it can often be dealt with much more speedily. And although you're paying for the arbitrator, it works out quite good value and not as expensive as you'd think.
Yeah, well, I guess the difference is you know what the cost is, as opposed to when you go to court, you've got no idea really of how long it's going to take. And as you say, there's facts and things that happen along the way, which in my experience usually ends up with, you know, because of how long you're in this process, with two people communicating through their solicitors, which costs every time, and the costs just keep racking up. Whereas I guess with arbitration, you know upfront what that cost is, and you have a timeline and you work to that. And I guess probably because you know what you're paying for, it's in your best interest to try and settle and get to that point, isn't it?
Yeah, I mean, most arbitrators quote actually a fixed fee, so you know exactly what it's going to cost before you engage in the process, which is really helpful. Although obviously everybody's always trying to encourage settlement, I just want to be clear that the whole point of arbitration is actually an adjudication. So it is to have a hearing and to get the result from the arbitrator as a sort of judge, as it were, at the hearing at the end of the day. And they write a very good judgment, which in arbitration is called an award or determination if you're talking about children cases, and that you get to keep that. It's a really good document that you keep.
And so what's agreed in arbitration, is that then legally binding?
Yeah, so when the arbitrator makes their determination, they'll set out what you've actually agreed possibly along the way. Sometimes you don't agree anything, sometimes everything is in dispute, and the arbitrator has to adjudicate on every point. But then they set that out very, very clearly in their document. And arbitration is very binding. There are some grounds of appeal, and in fact, there's recently been a case called Haley in the courts, which determined that the grounds for appeal in arbitration are the same as in a family case. So that's made people feel very comfortable and confident that they can appeal, but the grounds are limited. It's basically if the arbitrator's gone wrong, and then you would be able to appeal. So it's the same as it would be for the court process.
Yeah, and obviously we know the court process is, as you say, 12 to 18 months minimum, if not longer, especially with, you know, COVID and everything that's happened. But with arbitration, roughly what are the timescales associated on average with arbitration?
I mean, basically, you can agree with the arbitrator whatever you want. I've had one example where the parents needed to determine which school their children went to. And so it was really urgent. They'd sort of tried to agree it beforehand, couldn't get an agreement. They'd been to mediation, that hadn't worked. So they got referred to me as an arbitrator. And I was able to say, well, I happen to have some time next week. I don't need to hear from anybody like an independent social worker or anybody like that. I'd like you both to do statements, and then I want to hear your evidence. So we had the hearing within a week.
Wow.
And then I wrote my determination within a week after that. So I'd agreed at the outset what my fee was going to be, how quickly I could list the hearing, and how quickly I could write my determination. And I was able to keep that. So the whole thing from beginning to end was just 2 weeks. I mean, that was exceptional. And that was obviously because there was an urgent issue. They needed to sign the children up to school. But I think most people's experience is that they will have a hearing within 3-4 months. And then the determination or the adjudication is generally written up within 2 weeks to 3 weeks.
Well, that's a big difference, isn't it? That in itself, just because I think people underestimate not only the financial cost that goes into these kind of long drawn out processes, as say when communication breaks down, but also the emotional turmoil, not only for the clients involved, but also for the, you know, for the children who are living in that scenario until, you know, the sort of limbo land before something's agreed. And you've mentioned that obviously it goes across the same as court, you know, financial complications, as well as, you know, agreements around children. Are there any scenarios in which arbitration isn't the right course of action, and something where you would say arbitration isn't right in this case, you would need to go to court?
Yeah. So there are certain aspects of both financial cases and children cases that are outside the scope of arbitration, and I'll just run through them really quickly so that everybody understands. So in financial cases, the arbitrator never deals with the divorce itself. So if you've got a defended divorce or you've got a dispute about your divorce, they won't be able to deal with that. They also won't be able to deal with cases where there are third parties, like, for example, trustees, unless that third party agrees, because an arbitration is just between the couple. And so the arbitrator needs to have the agreement if there's a third party involved. And so there wouldn't be an arbitration dealing with other jurisdictions. This is dealt with in the law of England and Wales on its own. In terms of children cases, we decided that they were so serious that there wouldn't be arbitrations dealing with surrogacy, adoption, care proceedings, and things like that. And also, there's no arbitration for leave to remove cases involving non-Hague countries. So you can apply for arbitration to deal with leave to remove in the UK and leave to remove to other countries, as long as they're what we call Hague countries. So they've signed up to conventions. So actually, if you think about it, nearly everything that you could deal with in the court, in the court, can be dealt with in arbitration. So it's really wide-ranging.
And in respect to the solicitors that you would instruct, does that matter whether it's court or arbitration, or solicitors are able to represent you in both scenarios?
Yeah, now we launched the scheme in 2012. So now lots of solicitors have had lots of practice of dealing with arbitration, and they're very used to it. If your solicitor says to you, well, I don't really know that much about it, and they're sort of indicating that they're not willing to go into arbitration with you, then I think it would be worth thinking about asking another solicitor to represent you. But most solicitors now are pretty confident about dealing with arbitration cases.
And is it just the solicitor? You don't need any other specialists around? It's literally just your solicitor and the arbitrator who are kind of in that process.
In really big cases, barristers also come in to represent, as they would in a court hearing. But what I suppose the beauty about arbitration is that you have solicitor arbitrators as well as barrister arbitrators and judge arbitrators. So some solicitors feel more comfortable going in front of and dealing with a solicitor arbitrator. So that's quite helpful. I mean, obviously, if you need expert evidence, for example, in a children case, if you need expert evidence, the parties and the arbitrator can agree to appoint an expert, whether that's a child psychologist or an independent social worker or something like that. And again, in finances, if you need an expert, for example, a valuer, a forensic accountant, somebody who specialises in tax, they can all be appointed, as they can in the court, in court, to come into arbitration to advise. Okay,
so actually it really is almost like a mirror image, the only difference being obviously the cost and the timeline.
Yeah.
Fantastic.
Yeah.
And in the sense of best outcomes, what's the kind of, when you look at court process versus arbitration process and the outcomes that people get to as a result, in your experience, what do you kind of see in the sense of how people then come out of the process the other side?
Well, some arbitrations are as hard fought as some court cases, but I would say the majority of arbitrations are conducted in a more civilized way. And as I've indicated, the parties are more involved, and it's because you're paying the arbitrator frankly has to take notice of what you're saying. And so you're much more involved and engaged in the whole process. And I think most people come out of it feeling that they've been properly heard, that they've been given the opportunity to say whatever they need to say, that there's no queuing around waiting for a judge who may not have read the papers, that the arbitrator that you've paid for is wholly engaged in your case, dealing with just you on that day, nobody else, and that they're giving you their fullest attention, that they're looking at everything right the way through to think about all angles of the case, and then writing a very clear, concise judgment for you. So I would say the majority of people, I think everyone I've spoken to, has said the process is much better. than court. And so if you're concerned about maintaining your relationship, which is obviously something that people are concerned about when they get divorced, I would say it's really important to think about arbitration as an alternative, and to think that it would maybe helpful by the way it's conducted and how it's all dealt with for your relationship going forward.
Yeah, definitely. And we had Susan, Samantha Woodham on here not so long ago, talking about how, as in her experience as a barrister, the worst place for any family to end up is court, and that's her bread and butter. But she said it's the worst place, and everyone would agree. And it sounds like, you know, if you're going to go down that route, that you need to have that sort of level of process around getting divorced, that arbitration is definitely the healthier way to go about that. If, you know, there's no other, you've tried mediation, etc., and those things haven't worked. Because, as you say, maintaining those relationships, which all the members on here need to do, is, you know, it really does pay dividends. And I think, I'm sorry,
I was just going to say that some people also start off in the court process and realize what it's like, and then come to arbitration. So the good thing about arbitration is you can come into it at any point. You can deal with your whole case in arbitration. You could deal with just one discrete part of your case in arbitration, but it's really, really good that you can also say, for example, you may have had a hearing and the judge may say, well, the next hearing, I'm looking at my diary, that's going to take another 9 months before it's listed. And you might then contact an arbitrator and they'll say, well, I can fit you in next month. So, you know, you can come out of the court process into arbitration as well.
Yeah, and I'm guessing not many people go from arbitration and choose to go to the court process. The other way.
You actually can't do that, because once you're bound to arbitration, you have to stay in arbitration.
Oh, interesting. Okay. And do you need to, for all those discrete sort of issues that can arise, do you go back to the same arbitrator, or is it best to stick to one arbitrator, or do you change it? Sort of what's the...
Well, typically you're only dealing with a discrete issue because all the others have been agreed, and then you just have the one arbitrator. But if you've had a really good experience with that arbitrator, which is what everybody says, they all really rate being with their arbitrators, then you can just go back to that arbitrator if another issue arises. Because the point of arbitration is that they deal with one thing, you know, they deal with, you employ them, as it were, to be the arbitrator to resolve your dispute for you. And once it's resolved, that's it, they finish their work. So if something else arose, you'd have to go back and employ them again.
Yeah, okay. That's really, really helpful. And I think especially the point that you made earlier about being heard, because I hear that a lot, about the fact that sometimes the issues of the breakdown of the marriage, one party or the other don't feel like they've been heard by the other one and want their day in court to be heard. And actually it's a place that often you don't get heard. And I think people get this idea from, you know, watching television and films, etc., that they get their day in court and they get to kind of stick it to their ex and say everything that they feel, and they get their moment. And actually that's not what court's there to do. And actually people can often come away very disappointed, and they don't get that closure that they think that they're going to get from that process. And actually just go through a lot of emotional pain and you know, for a very long time to get to that point. Whereas, you know, being heard is so important, I think, for the emotional kind of closure and moving forward as a family. And actually arbitration is a much better setting for that, that closure to take place emotionally, as well as, you know, obviously legally as well, which you don't get in court. And I think that's a really interesting point, and something that, you know, I really like to highlight to members, because I think that's something that kind of goes missed. And there's definitely a kind of a myth around that with the court process.
Yeah, I mean, I just want to be clear that arbitration isn't, of course, mediation. So it's not just about the couple trying to resolve their problems together with an independent neutral facilitator, which is what mediation is. Yeah. In arbitration, the arbitrator will listen to both sides and will give really good opportunities for both sides to say what they need to say, but then will ultimately make an adjudication. So they're going to say, well, I've heard you both, I've given you all the opportunity to say what you need to, and now I'm doing this. So that's really how arbitration works.
Yeah, and like when you go to court, we've discussed mediation here before, around the fact that mediation is almost a precursor for going to court. Is it the same for arbitration?
No, because as I've indicated, when you sign up to arbitration, you're signing up to be in an alternative system, and you have to stay in that system because you've specifically chosen not to go to court. So you're bound by the decision of the arbitrator. So only if the arbitrator went wrong and you had to appeal the decision can you do anything about it. You can't then go back to court because you've chosen another system. And the courts are really very much in favour of arbitration. They think it's a great system. We're really supported by the judges. They're basically saying that, you know, as many cases as possible should try and go into arbitration to free up some court space. And so people should be thinking about it in this way. It's an alternative to court. And so when they speak to their solicitors, they might say, well, what about arbitration? If their solicitor says, yeah, good idea, then phone an arbitrator. And I would also just say this, I think it's really important for people to understand that arbitrators are really keen to do this work because it's relatively new. It launched in 2012. It's gained huge credibility and a great reputation. And so what arbitrators often say is, well, why don't we have what's called a pre-commitment call? So before you sign up for arbitration, you're bound by the process. Let's have a call with the husband, wife and the lawyers. You don't pay for it. That might take about half an hour just to talk about what arbitration would look like, how you'd be involved in arbitration, how the arbitrator works, what the timeline would be, and how much it would cost. And so most arbitrators offer that, which is a really good thing.
Yeah, brilliant. And just on the side of mediation, is there any requirement to have tried mediation ahead of arbitration, or can you go straight to arbitration?
You don't have to have tried, you can go straight to arbitration.
Fantastic. Thank you so much. It's been brilliant to speak to you today and to understand more about this, because as you say, I think that it offers so much to the couple, especially trying to preserve those relationships, which all the members here have to do. You know, everybody has children, everyone is still a family at the end of this process and still has to have a relationship with their ex. So in order to be able to do that in a way that one is so much quicker, so it's not going to take the same emotional and financial toll on you as a court process would, and just to be aware of what those options are, I think is really, really helpful. And to hear, you know, the support that it has across the legal sector as well. I think that more people need to know about it. So obviously, as we do with all of our experts, we're going to share Suzanne's details on the Fresh Start membership. So if you do want to follow up, or get in touch with Suzanne. If people are looking for arbitrators, where would you suggest that they go and look for?
There's a website called the IFLA, which is Institute of Family Law Arbitrators, and it's there. Find an arbitrator, and F is financial and C is children, and F and C is both financial and children, and there's a huge list of arbitrators there.
Fantastic. I will include a link to that website as well, along with Suzanne's profile. So if you have any questions, I'm sure we can follow up, or you can approach Suzanne directly, or instead look at the website. Thank you so much for your time today. It's been really, really helpful. And I will see everybody else back here for the next Fresh Start episode. Thank you.
Okay, thanks very much. Great to talk to you.
And you.